নমস্কার বন্ধুরা, টিচার্স ডায়েরি ইউটিউব চ্যানেলে আপনাদের সকলকে স্বাগত। বন্ধুরা, এই মুহূর্তের একটি সবচেয়ে বড় আপডেট যেটা উঠে আসছে সেটা হচ্ছে যে অনারেবল জাস্টিস অনিরুদ্ধ রায়ের বেঞ্চে যে 16,500 সংরক্ষণ মামলা চলছিল তা কিন্তু পুরোপুরিভাবে খারিজ করে দেওয়া হলো। চলুন সেটাই আমরা আজকের ভিডিওতে সরাসরি একবার দেখে নিই।
The petitioners participated in the teacher eligibility test 2014 in terms of the notification dated 26 June 2015. The petitioners qualified in the teacher eligibility test 2014 and the petitioners are all trained candidates having B.Ed and DLED qualification respectively. The petitioners are all TET qualified, but mere TET pass do not make them qualified unless they have the other qualifications. My lord, I do not know who are having DLED and who are having B.Ed. B.Ed are unqualified. So at least at the instance of the B.Ed candidates, it not maintained.
Microphone.
B.Ed are not qualified. So at least at the instance of the B.Ed candidates, REIT is not maintainable. REIT petition do not specify who are B.Ed or who are DLED. This has been held by the Supreme Court.
Yes, the rule of the game. If the rule of the game specifies B.Ed only, then B.Ed.
Rule specified, my lord, when the selection process, my lord, held in 2020, at that point of time, both B.Ed and DLED eligible as per NCT notification. But, my lord, the REIT petition was pending throughout India. In all, it's a pan-India aspect, my lord, because NCT made the B.Ed qualified candidate eligible only in 2018. Well, the first REIT petition was moved in our High Court, but I could not get it heard. I was moving for them, against them, but I could not get it heard. Well, in the meantime, Rajasthan High Court matter was heard, and the Rajasthan High Court was the notification of NCT, my lord, making the B.Ed qualified candidate eligible. Now, that was taken before the Supreme Court. Now then, Supreme Court issued notice to all the parties throughout the country to come and make your submissions. Our REIT petition was also taken over there by one application. And ultimately, Supreme Court held the NCT notification unconstitutional and therefore quashed. Now, as a result, the persons who have been appointed as B.Ed, their appointment goes, so they moved on clarification application. Then Supreme Court said in the clarification application that those who have already appointed, they are set. Those who are already appointed, those are set, but the rest are not. Similar, they are not selected or appointed, so they cannot move it.
So have you disclosed this in your affidavit in opposition?
This is the latest judgment.
No, not only judgment. You have taken this point.
Yes, B.Ed qualified I have taken for.
Regarding B.Ed, they have taken point, in reply, I have stated that, in the recruitment process of 2020, they appointed, more than 7,500 B.Ed candidates.
But I tell you, Lordship,
and the order, passed by.
What he has said, even if they were appointed, sir, here, the issue is different. Your short point, who have availed of the reservation advantage, they cannot be included in the general category forever.
Yes.
Their door is shut. That's your short point. Nothing more than that. Mr. Sanyal is saying, yes, B.Ed were appointed. I don't disagree to that. Subsequently, Supreme Court said B.Ed were appointed at a juncture when that notification was not quashed. But subsequently, Supreme Court quashed, disallowing B.Ed. With a caveat, those who have been appointed, they will remain.
The order passed in Devesh Sharma matter, the B.Ed matters, dated, 11th August 2023. The order, effect of the order prospective, not the retrospective.
That's right.
From the date of the order.
Oh no, if the Supreme Court directed, Honorable Supreme Court directed those who have appointed already, their appointment is saved. Still will you argue that it is prospective
No, no.
and retrospective? Then he is saying the same thing.
Yes.
You are saying the same thing. It is the Supreme Court who had directed that those who have appointed already they are saved. The rest are not saved. Then how do you argue this? Even if it is under 142, even if. That cannot be your, that is no plea to be available to you.
In the judgment of the Honorable Supreme Court, but this is the main judgment, this is the clarification. Both.
No, Mr. Sanyal, today we have hardly any time. First, today you proceed with your points of argument.
This is fast.
এটা নিয়ে নিন, নিয়ে লিখুন রেসপন্ডেন্ট নাম্বারস 3 to 5. রেসপন্ড আর 3 to 5 ডেটটা দিয়ে দিন 1 নম্বর। জাজমেন্ট দুটোতেই লিখুন 1 নম্বর। আর 3 to 5. Yes.
Now the
This
second,
is your first point.
now the second one you're looking. This is a recruitment process of 2010. 2020. Panel was published on 2021. It got lapsed 2022. In the same recruitment process, matter was taken up before the Honorable Supreme Court by my learned friend. Supreme Court says that this matter has, the panel has lapsed. Nothing can be done with it.
And it has lost its life.
Pendency immaterial.
So, perhaps I have asked him the right question.
Yes, your loss, the first one.
The right question I have asked.
My lord, your losses will find just paragraph Roman 2 and 3 of
No,
paragraph
one second.
29.
এটা অন্য দিল। Where the Supreme Court said that? In these two?
2024 SSC online. This one. That was to be.
ওটাই 3 করুন। আর 3 to 5 আজকের ডেট 3। আর এই দুটো ওখানে আটকে দিন, ওই ফাইলে আটকে দিন। হ্যাঁ, দুটোতেই এক করুন, একই কানেক্টেড ম্যাটার। ওটা 2। Yes. So that is really what is troubling me. Then I will come the next point.
Now, my lord, kindly will look, my lord, Roman 2, 3 and 4.
Where from?
Page paragraph 29.
Judgment. Wait.
This is, oh, yes.
Didi. Roman? Paragraph?
Paragraph 29.
Huh?
My lord, let us go through the entire paragraph 29, very short paragraph.
1 second. No, first you show me from this judgment, this arose out of the same recruitment.
And that's paragraph 29 itself.
Acha.
My lord, first paragraph, Roman 1, 29. My lord, in the light of the above discussion, the following conclusions are reached. Number 1. The manner of shortlisting candidates for appointment as suggested by the division bench in the impugned judgments is inconsistent with the procedure laid down under Rule 8 of the Recruitment Rule 2016 and those cannot be sustained. Malak, this is governed by Rule 2016. Then, the panel or merit list as notified on 15th February 2021 stood extinguished after expiry of 1 year, that is to say 15th February 2022, as per Rule 12 of the Recruitment Rules 2016. My learned friend has placed elaborately Rule 2016, but on another point. Roman 3, no extension by competent authority was granted to the 15th February 2021 panel, and therefore no relief can be granted to the candidates who approached the court in May 2022. are long after the panel stood extinguished. My learned friend's client affirmation of the writ petition I have checked. Malad, this is in the month of January 2023. This writ petition affirmed on 13th day of January
Aste. 13 January.
2023. Page running page 291.
All right.
Then 4. No further appointments is permissible.
That is what was really
On the
troubling me.
process initiated on 13th February, December 2022, when a fresh recruitment process has commenced.
Here also fresh recruitment commenced. Next recruitment process. And not only that, this was really troubling me. This was from the beginning. It was troubling me. That how far I can lay my hand, even if I find illegality.
No, Malad, after this, Malad, I'm with this one without considering to this. This cannot be done after because the panel hasn't prepared everything. I tell you now. Malad, Nirod Kumar judgment, Jitendra Singh's judgment. Oh, Nirab Kumar, anyway.
And give me that.
That's your loss. My learned friend has cited you before losses.
Which one? 17 or 19?
19. Well, all the judgments I just, according to my memory, I keep the glimpses. Because one matter I fought with my learned friend.
No, but one thing, Mr. Sanya, if ultimately this be the ratio, if by this my hands are tied,
Futile exercise. Futile exercise. But even then, on that point, I have the sufficient. So would your losses go to that or not?
that's precisely.
That's your losses.
That's precisely. Just take your seat. After this.
Yes.
So you admit that this Supreme Court
My
judgment.
learned friend, one point. This was my learned friend was the advocate on record.
No.
And Malad, move
In
this
the-
matter before the Supreme
No, I am appealing
Okay. All right. Doesn't matter. Doesn't matter.
before
Doesn't matter. Whatever is written is written. You admit that this SLP arose out of the same recruitment process?
Yes.
Fair enough. Thank you, sir.
Yes.
Now, if that be so, how can I travel beyond 29, paragraph 29? Which the question I asked you before you ended your submission. That's the
After
question.
expiry of the panel.
No, after the observation of the Supreme Court, mandate of the Supreme Court. How can I lay my hand? Simple question.
But there are, my lord, 2-4 judgment are there.
Not
To show-
required. Not required. I am.
Even, my lord, if any illegalities, my lord, cropped up, my lord, in the recruitment process,
Void.
and that is,
Sir, I am telling you, the proposition of law, void, ab initio, honest, wholly illegal, total wrongful. But after this mandate, because it is service jurisprudence, the right have settled. Why that question has cropped up in my mind? And I asked the relevant dates, expiry of panel and filing of writ petition. Because the right had settled. The panel was allowed to be settled. The 16,000 candidates, they were selected by the state authority. The presumption is the moment state authority selected them, it's a right selection unless quashed. Right?
yes.
Now, when a right has settled for last 5 years,
Not 5 years, but 20,
2 years,
2 years.
2 years, let's say, 2
years.
months,
Yes. Right.
and this mandate is there on the face of, it stares at me. Why should I go further? Why should I
rights
go-
crystallized, Malad.
Right has settled.
That crystallized totally.
Crystallized. Now today, if the employer wants to take away the employment of any one of these 16,000, it has to be done with due process of law. Simply cannot be done. Why? Because the right is settled. Now, in such a situation, the equity definitely comes.
And court can interfere.
Court, but the Supreme Court, Honorable Apex Court. Ashu, sorry, this is not the matter. Ashu.
But my lord, the petitioner able to, my lord, show before your lordships by the mistake in preparation of the panel.
But I
That should
cannot
be-
go beyond this. I cannot go beyond this. I cannot go beyond this, sir.
But can it be, my lord, adjourned for 1 week, my lord? To, my lord, bring some judgment to show, my lord, that after cessation of the panel,
No. You submit me in law that this is not binding on me. Submit me in law, which is the law point. Submit me here.
at present, my lord,
No, forget about the judgments. You first submit me. This is a decision which is not binding on me. A decision of the Honorable Apex Court is sitting in a single bench is not binding on. Show me.
but the writ petition, my lord, which is, my lord, the formation of the SLP, my lord, is based on, my lord, vacancy, my lord, they are in the recruitment process.
Question on no uncertain terms. Honorable Supreme Court has held, don't touch it. Don't touch it. And the way, really I was thinking in this way. How can I? After the right is settled?
Settle law.
Ashu. Please assist me in recording the
Yes,
facts,
yes.
both of you. It is equally, it is Mr. Counsel, it was equally a very, very pleasantly sessions for me to hear you. To hear you on the point of law. Ashu. Through this writ petition, the petition asks,
Yes.
please assist me
Yes.
in recording the facts. Mr. Sanal, through this writ petition, the petitioners were the aspirant for the selection process arising out of the examination,
2020 recruitment process
out of the 2020 recruitment process
for the post of assistant teacher in
post of
primary school.
assistant teachers at the primary schools in the state. The petitioners participated in the teachers eligibility test,
2014.
14, bracketed TET for short TET. The grievance of the petitioners is that the aspirants who participated in the TET under the reserved category and thereby received the reservation benefits under the state policy could not have been included ultimately under the general category list, bracketed unreserved. General category, bracketed unreserved, bracket close, list. Mr. Dibyendu Chatterjee, learned counsel appearing for the petitioner, has very forcefully submitted that the moment the reserved category candidates after receiving the benefits of the reservation, are allowed to be included in the general category list, the same would amount to encroachment of the space for the general category candidates, and would be in violation of Article 14 of the Constitution of
And
India.
also for the candidate who obtained higher marks than the last day panel candidate, he might be reserved category candidate, but he can be placed pilot in terms of his merit.
Not required, because your challenge is this.
Yes, absolutely.
Paragraph. In support, Learned Counsel for the petitioner had relied upon the following judgments of the Honorable Supreme Court. Roman 1, দেখি এবার পুরো বান্ডিলগুলো দেখি।
বান্ডিলটা দেখি।
Roman 1, এটা নয়, আমি ফাইল যেটা করতে বলেছিল। রোমান ছেড়ে দিন। Roman 1, আমি লিখে দিচ্ছি, আপনি ওই ছেপে নেবেন। জাস্ট আমি একটুখানি বলে যাচ্ছি। ইন দ্য ম্যাটার অফ নীরব কুমার, এটা রোমান 1 দিয়ে দিলাম। নীরব কুমার, ঠিক আছে। রিপোর্টেড অ্যাট, আমি যেভাবে লিখি ওই ইটালিক্স করে বোল্ড, 2019 7 SCC 283। Roman 2, লিখুন দীপা ইভি, দেখে নেবেন। রিপোর্টেড অ্যাট 2017 12 SCC 680, Roman 2। Next, Roman 3, in the matter of Government of NCT, Delhi and others, rendered in Civil Appeal number 8259 of 2019, arising out of SLP all cap within bracket C number 11254 of 2019, dated October 24, 2019, Roman 3।
Yes.
ঠিক আছে। হলো? Paragraph. Mr. Subir Sanyal, Learned Counsel, appearing for respondent number 325, submits that arising out of the same selection process, submits that. What of which paragraph? 29 না কি বললাম? Which paragraph? You have shown me.
Paragraph 29. Page I just
না পাচ্ছি না, কোথায় গেল?
last page, last but one page.
দেবেশ শর্মা?
No. Ali Hossain.
তুমি রেফারেন্সটা পড়ে দাও না।
3, judgment number 3. Personal cleaning industry.
Oh.
এটা রিপোর্টেড হয়েছে কোথায় দেখা
Online.
Give me the dates. Give me the date. Mr. Subi Sanyal and such and such submits that the recruitment process was initiated on
On 23rd December 2020.
December 23, 2020. Full stop. The panel or merit list was notified on
15th February.
February 15, 2021, which stood extinguished after 1 year.
On
That
15th
is
February
on-
2022.
That is on February 15, 2022, as per the relevant recruitment rules, 2016. The writ petition was filed on January 13, 2023. এই ডেটগুলো সব বোল্ড হবে, এই ডেটের উপরই কিন্তু মামলা দাঁড়িয়ে আছে। January 13, 2023. Paragraph. Mr. Sanyal then submits, once the panel stood extinguished and expired, the right of the selected candidates, for about 16,000 in numbers, have already been settled and crystallized. And the same cannot be interfered with at this belated stage. In support, he relied upon full stop. He further submits that arising out of the same recruitment process, same recruitment process, the Honorable Supreme Court had dealt the issue in the matter of Ali Hussain, reported at 2024 SCC online SC 1189. এটা কত নম্বর হলো সিরিয়াল? আগেরটা 3 বলেছি, এটা 4। এই নিন দিদি, কি বললাম? Reported at পরে in the matter of Ali Hussain, হ্যাঁ দেখে নেবেন এখানে ভার্সেস ওয়েস্ট বেঙ্গল বোর্ড যা আছে পড়ে দেখে নেবেন। রিপোর্টেড কি বললাম? along with other connected appeals, না ব্র্যাকেটে করুন, আগে ব্র্যাকেটে করুন, সিভিল অ্যাপিল নাম্বার সি ক্যাপ এ ক্যাপ এন ক্যাপ বোল্ড হবে, সিভিল অ্যাপিল নাম্বার 1873 of 2024 ব্র্যাকেট ক্লোজ, along with other civil appeals. Paragraph. The relevant portion from the judgment in the matter of Ali Hussain Mondol, ওই পুরোটা লিখে দেবে ব্র্যাকেটে সুপ্রা, is quoted below. Paragraph 29 full quote করুন, লিখে দিচ্ছি কোট 1 প্যারাগ্রাফ 29, ঠিক আছে? ফুল স্টপ। প্যারাগ্রাফ। Full stop. Considering the ratio and the observation made by the laid down by the Honorable Supreme Court, in the matter of Ali Hussain Mundal Supra, and considering the observations made by the Honorable Apex Court therein, as quoted above, comma, this court is of the view that there is no further requirement to proceed with this writ petition. Full stop. Paragraph. Would you? See page 30, and you are asking me to proceed. See paragraph 30.
Paragraph 30 की judgment है.
All earlier order quashed.
See paragraph 30.
Yes.
Yes.
अरे ये judgment है ये bullish.
In view of the above, কি বললাম পুরো?
অচেনা লাগছে দেখ জানিস
Comma দিয়ে this court is of the view that, comma, there is accordingly, this writ petition WPA 1056 of 2023 stands dismissed, comma,
হিমাকলি
without an order as to cause.
কথা শুনেন
আচ্ছা মাথার উপর একদম লিখবেন this is a hearing matter upon affidavits একদম শুরুতে affidavits yes I have read affidavits hearing matter upon affidavits আসুন
ডিস্ট্রিক্টের শান্তিনিকেতন যাবে না যায় জিজ্ঞেস
এখন আর যায়?
হ্যাঁ যায়
কোথায় যাবে?
এই জাজমেন্টটা এই অর্ডারটা দাদা এটা তো জাজমেন্ট না অর্ডারটা হয়ে গেলে একটা সার্ভার কপি আমায় দেবেন তো কারণ ওই প্রপোজিশনটার জন্য সুপ্রিম কোর্টের জাজমেন্টটা দরকার আমার অন্য সময়
আমার কাছ থেকে আবার হয়ে পড়ে
একটু ভালো আছে অবলাইজড থ্যাংক ইউ